By agreement of the parties, and pursuant to Rule 21D of the Texas Rules of Civil Procedure, we're on the record in cause number. Albie, on behalf of the Department of Family and Protective Services, are you ready to proceed?
I'm ready to proceed, Your Honor.
Ms. Archer, on behalf of Kamanicum, are you also ready?
We're ready, Your Honor.
And the record will reflect that Kamanicum is present on this video conference hearing. And Mr. Jackson, on behalf of Robbie LaReal, are you also ready?
I'm ready. My client is not present, Your Honor.
And can you put on the record what's your client's status?
It's my understanding that my client's status is he's currently incarcerated.
All right. And did you advise him as much as you could to the time, date of this hearing?
Judge, I don't know that I have a record of that, to be honest with you. I'd have to ask my legal assistant if she sent that out. I'm sorry, I don't know that I have that in front of me.
Well, we'll take about 2 minutes for you to ask her.
Yes, sir. May I be excused for a minute?
You may.
Thank you.
And let me say, Mr. Harris will not be joining us this afternoon. He had some other issues that he needed to take care of, so he won't be here this afternoon. Mr. Jackson?
Yes, sir. Judge, on January the 24th at 10:31 a.m., we sent an email to Mr. LaReal about this date and time and provided him with the Zoom link.
All right. Then we are ready to proceed. As I was explaining while you were out of the room, Mr. Harris, the ad litem for the children will not be present today. He has some other issues, and so he has been excused with the permission of the court. I think there's several things that we need to take up this afternoon. First of all, as you recall, the jury verdict terminated the parental rights of both parents as to the oldest child. And it probably, we need to sever that and make that a separate trial. Mr. Alvey, would you concur with that? And is the department ready to make that motion?
Yes, Your Honor. At this time, we would move that you sever Kaysley's case or her portion of the case to make it separate from the other children's case so that there would be two different cases.
All right. So ordered. You'll prepare the order of the court?
I will, Your Honor.
And Mr. Jackson and Miss Archer are still in this matter at this time, so you'll need to submit a copy to them and also to Mr. Harris. I'm sure as counsel realizes under section 107.016, the attorneys appointed to represent the parents and the children are in for the duration unless the court gives counsel permission to withdraw, and that may or may not happen. That's up to counsel to file a motion to withdraw with the court. The second thing is, I think Ms. Archer, you had indicated that you wanted some clarification of visitation. Is that correct?
That's correct, Judge. As you know, before the trial, my client wasn't getting visitation because the counselor was afraid it would be detrimental to the kids to have visitation with a termination possibly coming. And that didn't happen. And now she's still not getting visitation because I think the counselor is still opposed to that. But my client is still doing services in her own way. She's still seeing her counselor.
Okay. And so the counselor, you say, is opposed or is in agreement with visitation? The
state's Mr. Alvey's counselor, or the counselor that the kids are seeing, has been opposed this whole time.
All right. And can you clarify, Mr. Alvey or Ms. Archer, is it the opposition to any and all visitation?
Judge, there's been some concern about how all of the children are going to react with visitation from Miss Nickum. So the children's counselor at this time has, up to this point, has not been ready to even begin therapeutic counseling, we would ask the court to, if he orders visitation, that it only be done through a therapeutic counseling session overseen by Ms. Souter.
All right. And that would be in person or via remotely?
I think remotely, so that Ms. Souter has some control over what that visitation looks like and how it goes
All right.
for the time being.
And I want counsel to recall that the jury found by clear and convincing evidence, and I have the verdict here in front of me. That Ms. Nickum knowingly placed or knowingly allowed the children to remain in conditions or surroundings which endanger the physical or emotional well-being of the children. And the jury's answer to all 4 children, including the 3 at issue, was yes. They also found by clear and convincing evidence that Ms. Nickum had engaged in conduct or knowingly placed the children with persons who engaged in conduct which endangers the physical or emotional well-being of the children. They also found by clear and convincing evidence that Ms. Nickum has constructively abandoned the children who have been in the permanent or temporary management and conservatorship of the Department of Family and Protective Services or an authorized agency for not less than 6 months. And 1, the department or authorized agency has made reasonable efforts to return the children to the mother. 2, the mother has not regularly visited or maintained significant contact with the children. And 3, the mother has demonstrated an inability to provide the children with a safe environment. And 4, by clear and convincing evidence that Kama Nickum has failed to comply with the provisions of a court order that specifically established the actions necessary for the mother to obtain the return of the children who have been in the permanent or temporary management and conservatorship of the Department of Family and Protective Services for not less than 9 months as a result of the children's removal from the parent under Chapter 262 for the abuse or neglect of the children, and only found by clear and convincing evidence that termination of the parental rights as to Case and Miss Nickum were in the best interest of the children. So the jury in its verdict did find by clear and convincing evidence that Miss Nickum had not, well, for lack of a better term, done what she should have done, and only determined that at this particular point in time, it would not be in the children's best interest to return to terminate parental rights. That is not to say that they determined that the children should be returned to Miss Nickum. They did not find, they only found that termination of parental rights was not in the best interest of the children. So, taking into consideration the jury's findings and the verdict that was rendered, and then the representation that the children's counselor is opposed to visitation, the court will allow limited remote visitation in a therapeutic setting, that is with the counselor, conditioned that Ms. Kama Nickum perform services provided by or approved by the Texas Department of Family and Protective Services. That is to say that she is not to do her own services in her own way, as Ms. Archer so well put. But these services that Ms. Nickum performs or completes must be approved by the Department of Family and Protective Services, and must be provided by them or approved by that department. So I think the law is clear that the court is responsible for determining what the terms and provisions of possession and access are. May not leave that up to the department, may not leave that up to the parents. It's the court's duty and responsibility to do that. And in view of the jury verdict, the court will allow therapeutic possession and access remotely with the presence of Miss Souter, one time per month while Miss Nickum performs her services
Once a week.
approved or provided by the Texas Department of Family and Protective Services. So I'm going to ask the department
Once a
to
week.
contact Miss Souter.
Natalie.
I don't know, is there somebody that's in the room with somebody who's,
I can hear my name, but no one's in here with me.
okay,
So I think, is my client trying to,
It's Tina. Someone named Tina.
who's Tina?
I'm sure that's the counselor, Your Honor. Miss
Oh,
Souter.
that's Miss Souter. All right. Okay, Miss Souter, good for you to join us. Can you hear us? Bet not. Mr. Albee, I'm gonna, oh, Miss Souter, can you hear us?
Judge, I thought what I heard coming through there was someone saying once a week on the visits, not once a month. I believe that's what I understood.
All right. Well, when I'm going to instruct the department to contact Miss Souter and determine how often that should happen.
I will do that, Your Honor.
All right.
may I ask a clarification question?
Yes, ma'am.
Will this be able to be a step-up program where if things are going well, she can have in person?
At this
At some
point, no,
point-
ma'am. At this point, no, ma'am. And that's based on the jury verdict. It was in their hands, not the court's hands. And so they found all four of those things by clear and convincing evidence. And the court realizes that this will probably be appealed, but pending appeal, then that's what the order of the court's going to be.
Judge, you had asked me to research and find a couple of statutes concerning child support,
Right.
and I have
Right,
those.
let me finish with the possession and access. So you're clear on possession and access. Okay.
Yes, you're saying she would have to go back to court one day and get a new order to change that, or it would be changed based on the outcome of the appeal.
Well, under 263.501, 5031, the court is required to have a permanency hearing since the department has been appointed permanent managing conservator of the three children every 6 months. And so that could be handled at that permanency hearing.
Okay.
And that would be, so we'd have a permanency hearing within 6 months after the date the court signs the order. And so it's the purpose of this hearing to determine where we need to go so that the department can complete the preparation of the proposed order, and then have the court sign it, and then we'll set a permanency hearing within 6 months after that, and we'll see how Ms. Nickum, what services she has completed that have been provided by or approved by the Department of Family and Protective Services.
Thank
All
you,
right.
Judge.
All right. Now, Mr. Albee, on child support.
Yes, Your Honor.
And also, Mr. Jackson, for your information, I think Mr. Albee is going to reveal the statute to me. I was trying to find it, that allows this court to order Mr. Larrill to pay child support, even though his parental rights have been terminated, as to all of the three of his children. So, Mr. Albee, if you'd enlighten us, please.
The statute specifically that you're talking about that allows the court to order post-termination child support is section Texas Family Code, section 154.001 A-1 specifically says the court may order each person who is financially able and whose parental rights have been terminated with respect to a child in substitute care for whom the department has been appointed managing conservator. And then it goes on for other particular reasons where that can be set, but that's the the relevant part. So it's 154.001 A-1.
All right.
And then there was a question about minimum wage child support.
All right, before we get to that, let me inquire of Mr. Jackson and Miss Archer. Section 154.063 allows the court, says the court shall require a party to, one, furnish information sufficient to accurately identify that party's net resources and ability to pay child support, and two, produce copies of income tax returns for the past 2 years of financial statement and current pay stubs. I'm not going to jump either one of you out, but Mr. Jackson, do you have any of that information on Mr. Laurel?
Well, the short answer is no, sir. I'm going to try to, I had requested some of that information on January the 24th, which is also the same day that I gave him notice of this hearing.
And he wasn't forthcoming with that?
I haven't received anything to my knowledge, Judge.
All right. And Ms. Archer, same question. Has Ms. Nickham furnished you with any financial type information that code
What's the
section
matter?
refers?
She is not, Your Honor. She is asking if we could have a breakout room. I'm not sure if you do that in your court.
Well, I do, but I'm gonna do that toward the end. All
Okay.
right.
But no, I've not received that information.
All right. So, Mr. Alvey, on the and I believe the court requested that, did I not, when we received that day, when we received the verdict? Correct me if I'm wrong. If I didn't, I didn't, but I thought I had.
You did request it. I'm not sure what date.
All right. All right. Mr. Jackson, do you recall that at all?
I don't recall like right after trial. I don't remember that. You may have, but I know.
If I did, it's on the record. So
Yes, sir. But I know that subsequently, I believe that the court sent us out something in writing that said that you wanted something to that effect.
right.
I
All right.
believe.
That sounds right.
All right. So, Mr. Alvey, you've got a code section, because I recall there was a code section on presumptive minimum wage child support, but I wasn't sure how solid that was, to tell you the truth.
Specifically, Judge, section 154.068, which is the wage and salary presumption. Subsection A, in the absence of evidence of a party's resources, the court shall presume that the party has income equal to the federal minimum wage for a 40-hour week.
And have you done a calculation as to what that child support would be for either or both parents? Well, I guess it'd be the same if it's both parents, but have you done?
I have not, Your Honor, but we do that typically in our orders. So,
All right.
Yeah, I calculated $311 for Miss Nickham
All
for
right.
minimum wage support.
Is that all 4 children?
Yes, sir.
All right. And do you have Mr. Laril's?
I do not,
All right.
because I didn't know if he had any other children other than the 3 Lareal children.
Well, I think there's one that's not before the court that he has. It's a baby anyway.
That's correct, Your Honor.
I think there was some evidence to that. So,
That's correct.
So in Miss Nickham's, no, for Miss Nickham, did you consider that child in calculating her minimum wage child support?
I did for the child that was terminated, not before the court.
What about the newborn?
Oh, no, I did not. I'll do
All right.
recalculations, sir. I'm sorry.
All right. Yeah, we'll need to consider that. I don't know who reminded me of that, but thank you for whoever did that.
Your Honor, for my client, we really didn't have anything to submit as just for her individually, because she doesn't work. She stays at home with her baby. So
Is she receiving any kind of government assistance?
that's a good question. I can ask her that.
All right. All right, well, typically, what I have done is, I have ordered, even if it's below minimum wage, child support, so a parent does not forget they have children, even if their rights have been terminated. So, unless there's strong objection, I'm going to allow the department to calculate that minimum wage child support and, put that in the order that will be sent to the court. And I'll have copies sent to each of you. And then if you have objection to that, you'll need to let me know and let the court know in writing that you disagree with that before I sign. And I'll give you 5 days to review the proposed order before I sign it for objections, primarily as to form, but I will allow you to object to the child support calculation if you want to. All right?
Okay.
Yes, sir.
All right. And the only other thing I had was that I had made a note was indigency for purposes of appeal. And I think we covered that from the beginning. Ms. Archer, your client under 107013 is presumed indigent from the get-go. And pardon me, that wasn't a legal term. From the beginning. All right. And Mr. Larrill has not yet demonstrated his indigence as required by section 107.013 and I think Mr. Jackson, you have submitted the I'm going to call it paperwork for indigency to Mr. Larrill, have you not, sir?
Yes, sir, I have.
And do you know when you did that?
Yes, sir. Initially, you'll bear with me just a second, Judge. I sent the initial application out on December the 19th to his email address. And then is day before yesterday, I sent that to him via first class mail, U.S. mail. And also I provided Miss Nickel with that application as well in the event that she's able to talk to him. I believe I emailed that to her on the same day. And it was either yesterday or day before. I can't remember which.
All right. All right. So he's, have you received anything back from him?
No, sir. I just initially wrote him 2 days ago, so I wouldn't expect anything back.
But you didn't receive anything on the December 19th?
No, sir, not to my knowledge. I'll double check it after our hearing. If I learn different, I'll let you know. But
all right. And the court will state for the record, the court has not received anything either. I'm going to ask the department to check with Judge Graham's office to see if he's received it, to make sure that that's not been forthcoming. And so they've got the information and they know where to send it. So, or he knows where to send it. So we'll see what happens. I don't have anything else. Miss Archer, I think you wanted to, or your client is requesting a breakout room. You want her to just, I think she's still on. Do you want her to just call you when she gets a chance or
Well, I gotta get back in court, but I was
Yeah.
afraid she wanted me to relay something to you. So that was my concern.
What was that?
I didn't know if she wanted to tell me something now that she wanted me to relay to the court.
All right. Miss Morris, can you put Miss Archer and Miss Nickham in a breakout room real quick?
I'll try.
All right.
And Judge, just to be clear in the orders, are you ordering
And
post
I
termination?
can't do two things at once. Are we off the record?
Yes.
Okay, thank you.
Now she can't, I mean, you can talk to me, Leslie, but
I won't be on the record.
it won't be on the record.
Okay, I apologize. Just to be clear, are you ordering Kama to pay post-termination child support on Kaisley?
Yes, all four.
Okay, I just wanted to make sure that it was in both orders.
I mean, yeah, Casely and the other three, yes.